So I've been down visiting family, and it was a nice little relaxation, nice little break. I worked up another 170.1 recusal on Tyrant, Kevin Seibert. In my opinion, and I'm entitled to say this if I want to, I think he's a piece of shit. I think that anybody that doesn't respect the constitutional law or sworn oath has no honor or dignity. I think he's a turd. That being said, I think what I'm going to do, I'll go ahead and read you guys, and I'm going to make a video of the recusal. I prepared a recusal while I was down here. He denied my first recusal because he's a fucking turd, doesn't believe in people having their right to a fair trial. He's caused 6 other sheriff deputies, 2 lieutenants and a sergeant, to end up getting a lawsuit coming their way. So I have this new recusal I'm going to be submitting. I'm going to read the introduction to you guys. It's a little extensive, so bear with me. Introduction. It says, I wish to formally record that the Tuolumne County Superior Court and public servant, Kevin Seibert, have allegedly violated fundamental well-established principles of the United States Constitution. These principles, which Mr. Seibert swore an oath to uphold and protect, form the core responsibilities of all judges in the United States. This oath represents a solemn agreement between the government and the people. It is required that all government employees, as a pledge to protect fundamental laws of the Constitution crafted by the people for the people in 1783. This is a basis for the honorific, your honor, afforded to judges. When a judge fails to uphold the oath, it brings dishonor to the bench. Kevin Seibert is now accused by a member of the sovereign citizenry, Nathaniel Smith, of dishonoring the robe and deceiving the people who compensate him for services he is failing to deliver. I contend that Kevin Seibert has become a tyrant, using the color of law to intimidate a member of the California citizenry, which, according to the California Constitution, holds the ultimate power of the state. Allow me to elaborate. The California Constitution underscores the principles of popular sovereignty, ensuring that ultimate authority resides with the people of the state. This is manifested in several ways. Number 1, initiative, referendum, and recall. The Constitution permits the electorate to propose new laws, initiative, approve or reject laws passed by the legislature or the referendum, and remove elected officials from office before their term concludes, a recall. Number 2, legislative powers. The people have a direct role in the legislative process, a distinctive feature of California's governance structure. Number 3, framework for rights and freedoms. The Constitution provides a framework that safeguards fundamental rights and freedoms, evolving over time to embrace a more diverse and inclusive society. Excuse me for the sound. It's ridiculous. I'm watching a movie here. Hold on. There. It's annoying. Okay. These elements ensure that the people of California wield significant power in shaping their government and its policies. It is challenging for me and others to understand how a court could treat a father who had no criminal record and had never been arrested until Kevin Seibert allegedly abused his authority. I continue to experience abuse and deprivation of rights guaranteed by constitutional law, as does my son. I have not seen my son since January 28th of 2024. I am fighting for my son and will not cease until justice is served. This case has also become a cause for many fathers in Tuolumne County, as I have documented my experiences in an online blog. The Tuolumne County Superior Court is treating family court like criminal court by misusing domestic violence restraining orders or DVROs for purposes other than the intended use, and employing law enforcement as personal enforcers, resulting in federal lawsuits against each involved officer. The court has effectively aided the abuser in my case, allowing her to exploit the legal system to victimize a father who simply seeks to enjoy his life, liberty, and pursuit of happiness. Judge Campbell attempted to avoid accountability by striking a recusal from the record and not adhering to the rule of the 170.1. Had she submitted the evidence to a third-party judge for review, they might have reported her unethical conduct for allegedly kidnapping a child for her friend, Juley Salkeld. Instead, Kevin Seibert took up the case, providing me with only a 4 days notice by mail. Submitted on July 1st, with the hearing on July 5th, despite the 4th being a court-ordered holiday. This renders his orders void due to improper service, another violation of constitutional law, which guarantees my right to due process. For transparency, I will be sending copies of this motion to Hector Gonzalez, the CEO, the Attorney General's office in regards to the federal lawsuit, and the grand jury. I will also attach a copy of a writ of supersedis to highlight the blatant misconduct of the judges in Tuolumne County in their alleged attempts to support child trafficking. Another pressing concern is the absence of criminal charges against Juley Salkeld and Olivia Phillips. Forming alliances with individuals who exploit children to generate revenue in family court is reprehensible and should be avoided. It is important to note that constitutionally protected absolute immunity does not shield judges who violate the very document intended to protect them. Granting a temporary restraining order or TRO for a constitutionally protected activity while allowing an attorney and a mother to submit fraudulent evidence constitutes a felony and undermines the fundamental rights protected by the 8th and 14th Amendments of the Constitution. Additionally, approving a TRO based on a constitutionally protected activity transforms the matter into a federal question case, as evidenced by its status in district court for a constitutional rights violation, which causes the Superior Court to lose jurisdiction. The recusal of Kevin Seibert is not only appropriate but necessary to prevent further harm. It provides an opportunity for the judge to step aside and allow a fair and impartial adjudication of the case. This action is in the best interest of all parties involved, including the Tuolumne County Superior Court, which represents the taxpayers. The fact that a TRO was not dismissed within the 25-day timeline as required by California timing rules of a TRO, Rule 1.10, and the granting of a TRO for a constitutional violation leaves the matter open for collateral attack. I am now adding more federal law violations, increasing the amount of the lawsuit, and urging the lawsuit to proceed with haste. I urge the Tuolumne County Court to take these concerns seriously, to ensure that the recusal is honored to maintain the integrity of the judicial process. Then I go through Section 2. I talk about laws and case law to support my claims and removing immunity. There's about 3 pages worth of case law. Then I go into the conclusion, Section 3. In the interest of justice and preservation of public trust, it's crucial that Kevin Seibert withdraw from further involvement in this matter. Over the past year, substantial evidence has emerged documenting fraud and unethical conduct by several parties involved. Approximately a year ago, I released a video expressing my belief that the court intended to grant full custody of my son to the other parent and unjustly incarcerate me as part of a premeditated scheme. That actually transpired. The allegation constitutes a serious charge of child abduction under 18 U.S.C. 242, which carries a severe penalties, including the possibility of life imprisonment. I cannot stand idly while my son is placed in the custody of an abusive parent, facilitated by attorneys and judges who exhibit clear psychological issues. It is in the best interest of all parties to cease this unethical behavior immediately and return my son to his father, Nathaniel Smith, who is demonstratively the healthier, more capable parent. Contrary to any misconceptions, my parenting skills are sound, and my commitment to my family is unwavering. Olivia Phillips, Juley Salkeld, judges, and law enforcement involved in this matter have harmed my son's mental health, either for personal gain or due to toxic egos. This is shown by the minute order dated on July 7, 2023 regarding the DVO, which supports my assertions and constitutes protected speech. This frivolous TRO should be vacated for numerous reasons, or a new judge should be assigned who will not permit such prejudice and bias attacks. Dated August 28, 2024, Nathaniel Smith, loving father of Carter and defender of his rights, president of Fatherly Freedom Incorporated, 501c4, Nate at fatherlyfreedom.com, honorably pro per, signed by me. So this is going to be turned in. I have a hearing on Friday. How did that get twisted? Okay. Oh, great. Okay, so I have a hearing on Friday, August 30th. This is going to be turned in more than likely tomorrow. And basically on that context, good luck, you fucking pieces of shit. And when I say that, I'm talking about the child traffickers like Clint Parish, who likes it when little kids call him daddy because he's a nasty little fuck. Jim Prains, who wanted to jump on board with these child traffickers. It's unfortunate you had to jump on board, man. You should have done your research before you started running your fucking mouth. And so that's where we stand. Diego Martinez, you're a disgusting piece of shit. You like to traffic. You're jumping on board with a bunch of child traffickers. Wait until this lawsuit's all done. Good luck, you turds.